Judge Raymond Dearie held his first hearing as special master in the case of documents seized at former President Donald Trump's home in Mar-a-Lago. The hearing was held on Tuesday in a Brooklyn federal court. Dearie told Trump's lawyers they needed to provide proof that the documents marked classified were in fact declassified, as the former president claimed in previous statements on Truth Social. Trump attorney James Trusty replied that their team was not prepared to do that without the necessary clearance to review the documents in question. Trusty added, "The Presidential Records Act does supersede traditional classification concerns, and that presidents do have unfettered access along with unfettered authority." Trump's legal team has made the same arguments in their filing Tuesday with the 11th Circuit Court of Appeals, in response to the DOJ's request for an appeal of the special master ruling. The Trump team further claims that the burden of proof is on the DOJ to prove the documents were indeed classified. They also point to Executive Order 13526 enacted by President Obama, which gives the president absolute authority to declassify any information without being subject to the approval of bureaucratic agencies of the executive branch. At the hearing in Brooklyn, Special Master Raymond Dearie still demanded that Trump's legal team provide specific proof of declassification, saying, "If the government gives me prima facie evidence that this is classified, and you decide not to advance a claim of declassification, as far as I'm concerned, that's the end of it." Trusty argued that this was outside the scope of Dearie's authority as special master, and that their team should not be forced to divulge their defense at this early stage in the event of a future indictment. Dearie disagreed with both statements and told Trump's team, "You can't have your cake and eat it too." At the same hearing, Dearie asked the DOJ how they would proceed if their appeal with the 11th Circuit was not granted. Prosecutor Julie Adelstein replied that the government would consider seeking other appellate options. Dearie ended the hearing by instructing Trump's team to select a third-party vendor to scan the documents for online review by both parties. They have until this Friday to submit their choice to the judge. On Wednesday, September 21st, the 11th Circuit Court granted the DOJ's request for a partial stay pending appeal, a ruling which allows them to continue their review of documents seized at Mar-a-Lago.
A president has the power to declassify.
Correct.
Okay. You had said on Truth Social a number of times you did declassify.
I did declassify, yes.
Okay. Is there a process? What was your process to declassify?
There doesn't have to be a process, as I understand it. There's different people say different things, but as I understand, there doesn't have to be. If you're the president of the United States, you can declassify just by saying it's declassified, even by thinking about it, because you're sending it to Mar-a-Lago or to wherever you're sending it. And there doesn't have to be a process. There can be a process, but there doesn't have to be. You're the president. You make that decision. So when you send it, it's declassified. I declassified everything.
Subscribe to Free Republic for more on this and other important news stories.